Hi, good morning, everyone, and thank you for joining us today for our annual labor law update. Some of you may be familiar with me, but if not, my name is Angela Toomey, and I've been the HR director here at Morrison Garritano for about 9 years, since 2015. And today I'm joined by Kristen White. She is Morrison Garritano's HR compliance consultant who brings over 2 decades of experience ranging from benefits management to payroll and HR operations, and she's well versed in navigating complex regulatory environments. We also have Nicole Cam, partner attorney of law with Fisher Phillips, who represents a broad range of clients from small businesses to national companies in a variety of industries, defending employers against individual class claims of discrimination, harassment, retaliation, wrongful termination, and wage and hour violations before state and federal courts and administrative agencies. So before we get started, I want to thank you all for answering this question when you registered and share the results with you. As you can see, when we asked the question, how confident are you regarding new labor law requirements? Most of you landed in somewhat confident section, but that's not to say that there's not a lot left to learn. So, which is why I imagine you're all here today. And if you're still a little unsure about the new regulations or how they impact your operations, we hope the next hour will provide you with some clarity. And so today we're going to talk through several new or updated employment regulations knocking on your door for 2025. Nicole is also going to walk us through some real world cases from 2024 and highlight those rulings. And then we'll close with a live Q&A session. So remember to add your questions in the Q&A feature at the bottom of your screen, and we'll be sure to address it. Please note that we do have a large audience today, so if time doesn't permit us to address everybody's questions, then we'll put together that FAQ resource that Sarah mentioned, and we'll release it with the recording and the presentation slide deck. So with that, Nicole is going to get us started.
Thank you so much. Thank you to everybody at Morrison Garritano and everybody who's joining us today. It's such a pleasure to be back with everybody. I love to talk about the new employment laws. You know, we spend so much time tracking the laws that come down, the bills, following the case law. And, you know, part of the reason we do it is obviously we need to be compliant. But also it just is such an ever-changing area of the law that it really is something that you have to stay on top of very regularly. But this is our opportunity to summarize 2024, all the bills that came down, and I'm going to talk about some of the cases that were relevant to employers in California in particular. This was a very big year for the legislative session. Over 2,000 bills were introduced, the busiest session in California history, and more than a 10% increase from the last session. So California is always on the forefront of employment law. What happens in California kind of sets the tone for different areas of the country, is usually one of the more kind of forward-thinking areas. We have laws that other states couldn't even fathom. My firm is a national law firm, and I have partners across the country. And it's so funny because we joke often about how California is just another planet when it comes to employment law, which makes it interesting, keeps us engaged, and there's never a boring day being an employer in California. So with that, I'm going to take us into our first topic in the legislative and regulatory action. The first topic is PAGA reform. PAGA stands for the Private Attorneys General Act. And if you don't know this term, if you have not heard this acronym, consider yourself lucky. PAGA has been a headache for California employers for 20 years. It actually went into effect in 2004, and over probably those first kind of 5 to 8 years, it started to get its feet with plaintiffs' attorneys. But kind of spending just a little bit of time on this because this is a huge topic that earlier this year, I gave presentations a full hour on this PAGA reform. So we're definitely going to condense it today. But just for those listening, PAGA is a bill that enabled individuals to step into the shoes of the state, basically deputized employees, to bring claims under the labor code for civil penalties against employers. So prior to 2004, only the labor commissioner could bring these claims against employers. And obviously, the labor commissioner is a government agency and its resources are limited. And so, what the state did is it said, let's let employees bring these claims on our behalf. And in order to kind of incentivize or supposedly level the playing field, those employees' attorneys can recover attorneys' fees if they prevail on these claims. And these claims are, again, for civil penalties under the labor code rather than the statutory. So it's almost a penalty on top of a penalty. The good part about PAGA is that it is and continues to be discretionary, whereas a statutory violation is more of a black and white, you either complied with the statute or you didn't comply. PAGA, there's always been this position that an employer, could make an argument and the employee could be awarded nothing for their PAGA claims, even if they prevail on the underlying statutory claim. And when I'm talking about labor code claims, what we usually see here are kind of the laundry list of claims that if you've had a wage and hour claim before the labor commissioner or in court or a demand of any kind, we see claims for unpaid minimum wage, unpaid or improperly paid overtime, missed meal breaks, missed rest breaks, or improper meal breaks and rest breaks. We usually see a pay stub violation. We usually see a waiting time penalty claim for those former employees. And, sometimes we'll see more nuanced claims like failure to pay paid sick leave properly or provide it, period. We'll see claims for other kind of more niche areas in the labor code, maybe reporting time pay or split shift, or oftentimes we do see a lot of the expense reimbursement. So kind of everything that falls under the labor code, everything having to do with wage and hour requirements for California employees. So PAGA came into being in 2004 and over time really started to become a real challenge for employers. And part of the reason why there was not a lot of guardrails, there wasn't a lot of case law, there wasn't a lot of guidance. And plaintiffs' attorneys really kind of found that this is an area that we can really capitalize on. It was almost the Wild West when it came to litigating it because of the lack of guidance. Over time, there had been proposals to revise PAGA, amend PAGA, repeal PAGA, and that's what happened this year. There was a proposed bill to repeal PAGA altogether. What happened in the middle of the year, in about May and June, is the two parties, so it's the employee party and the employer party, kind of labor and then the workforce, started negotiating because of the risks in taking the bill to the people, to the ballot, the cost in doing so, and the fact that, in negotiation, at least you have some control over the outcome. Now, a good negotiation, a good settlement, we always say, is where both parties leave unhappy because you're going to get some wins and then you're going to have to give up some of your points as well. So what we walked away with in effective July 1 for claims made June 19th or later was changes to PAGA that help employers minimize the penalties, respond to claims in a different way, and give them different arguments. Kind of, we have more tools in our toolbox now than we did before. Happily, thankfully, two of my partners, including one who's based in Sacramento, had the inside track. They were part of the negotiation. And so they had a lot of input on what changes should be made, what we're seeing in practice. And it kind of gave us a little bit of a heads up on what was to come. The main takeaways were in terms of penalty modification. So again, we're reducing penalties. So instead of maybe 100% of the penalty, if employers take certain steps, they can minimize those penalties up to 80% off, 80% discount on the penalty. So that's huge. That's fantastic. Restricting the scope of claims to those that the plaintiff suffered. And this is a sticky one because the way PAGA used to work was if the employee suffered one violation, so let's say they missed one meal break, they could bring a claim, a PAGA claim, for all claims under the labor code, even if they never missed any overtime, even if they never had an improper rest break, they could bring those claims. That was, we considered an issue. And so now the plaintiff can only bring claims that they suffered, that they were harmed or injured allegedly for, that they have standing essentially to bring. There's more manageability standards in litigation now in terms of, very similar to a class action where the claims have to be manageable. You have to be able to evaluate them on a group basis. Sometimes we're looking at, up to tens, if not more, thousands of employees. And so now manageability is an argument that we can make. And then the cure provision. So there's opportunities for employers to cure. There's very much, significant considerations that go into whether or not an employer wants to cure, but it's available if it is the right situation. So the main takeaway that I want you to think about coming out of today is, and if you don't mind going to the next slide, Sarah, thank you, is the one thing that all employers should be doing now is taking these reasonable steps to ensure wage and hour compliance, because if you do that before you get a PAGA letter or a demand for records or any sort of inquiry on those lines, you can reduce the penalties by up to 85%. But you have to show that you've taken those reasonable steps. And the statute defines those reasonable steps as conducting payroll audits, updating your employee handbook, which hopefully after today, you're going to go back and implement some of the changes we're talking about. Train employees on wage and hour requirements. So have those trainings, have those meetings, add to your agenda, to maybe your monthly meeting or your morning check-in, reminders about meal breaks, reminders about rest breaks, reminders about tracking all their time, recording all their time, not working off the clock. That if an employee feels that they have any issues with breaks, that they're to come to HR, they're to come to their manager. And then taking corrective action against managers who violate policy or wage and hour law. There's strict liability on the company for acts of managers. And so those managers really are the front line with the potential to create a fair amount of exposure for a company. The managers have to be trained repeatedly. We need to make sure managers understand what the law is, comply with the policies, and enforce our policies. And then taking the corrective action if there are any managers who try to circumvent those policies. One more point I wanted to add is just in terms of and this is just a little takeaway that I think is critical. There used to be an open question about the heightened penalties. So basically, under PAGA, there's a penalty for a first violation and then a second violation. So it's $100 and then $200 is kind of the default for the first violation and the second violation. There's been a debate over what's considered the first violation. Is it the first lawsuit? Is it the first pay period where somebody may have been paid improperly? And obviously, plaintiffs' attorneys and defense attorneys would take very different positions. Now it's been clarified by the reform that the first penalty, the first violation is kind of that first go around, and the heightened penalty, the subsequent violation, applies in two scenarios. One, where a court or an agency makes a finding or a determination that there was a violation, or if there was malicious, fraudulent, or oppressive conduct by the employer. So what this means is two things. One, for that second category, we're probably going to be seeing plaintiffs' attorneys include allegations more that there was malicious, fraudulent, and oppressive conduct to try and get to that heightened penalty. So that's fine. We can expect that to be in the pleadings. That doesn't mean that they're going to prove that. The bigger takeaway is that agency or court finding or determination. Now, most of these cases, the vast majority, do not go to trial. So you're probably not going to have a court determination, but you may experience a labor commissioner claim. So that's an agency determination or finding. Labor commissioner claims are fairly common. They're usually much more kind of narrow. They're usually don't involve plaintiffs' attorneys, even though it's possible. But a lot of times because they were relatively small and you could go through the hearing process and maybe kind of roll the dice on winning on that, a lot of employers would kind of play that process out. Now you have to think really carefully about whether you want to settle those claims early versus take them to a hearing and possibly have a finding or determination of a violation, because that could lead to that subsequent violation position. And so you want to try to mitigate that. So if you have a labor commissioner claim come in, think very carefully and strategically about how you want to handle that. And definitely, talk to counsel, talk to your team at M&G. Our law firm has created a PAGA resource center, particularly to provide those kind of meeting those reasonable steps requirements. We obviously, have a lot of team focused this time of year. They're completely underwater on updating and preparing handbooks. We have training materials available. We have products and materials that can help you conduct that wage and hour audit. So if you are interested in any of these resources, I welcome you to reach out. This is a big area of change and something that all employers should keep their eye on. And then the last point on PAGA, there is an exemption for unionized construction industry that are covered by a collective bargaining agreement. So if you're in the construction industry and if you're covered by a collective bargaining agreement, and the CBA prohibits all violations of the labor code that would otherwise fall under PAGA, you can be exempt from a PAGA claim. So if you're in this industry, that you may have an exemption that could apply to you, and definitely, make sure that the CBA meets all those requirements so you can make that argument if a claim is made. So that's about my nutshell on PAGA for now. The next topic is employer communications. So you may have heard the term captive audience meetings, and this is something that, has kind of come up from time to time, comes up a lot more often kind of in the union context, the labor organizing context. But now we have a statute that prohibits employers from threatening to discharge, discriminate, retaliate against, or carry out such actions against an employee who declines to attend an employer-sponsored meeting or participate in a meeting that's related to the employer's opinions on religious or political matters. So that might be something that does not come up in your workplace, has not occurred to you to do in the workplace, but if it is something that comes up, it's restricted. Now, you do want to keep in mind that, excuse me, that there are carve-outs. So if the meeting is a legal requirement, like a safety training, a health training, an unlawful harassment training, anything along those lines, you can require employees to attend that. But if it's anything outside of that, that's not a legal requirement, legal obligation, or to comply with some kind of statute or guidance or authority, then you really want to be cautious about requiring employees to attend those meetings. And if there are any policies in your handbook that might relate to this, you want to make sure that you're addressing and updating those policies as well. With that, I'm going to hand this over to Kristen to go into the next topics.
Thanks, Nicole. Those are some heavy topics. Okay, I'm going to cover our next few. We'll start here with the minimum wage increase. You may remember on the November ballot, there was a proposal to increase California's minimum wage even higher. That did not pass this round, but we still have this one that was planned to be in effect already. So the $16.50 you can see on the slide there, that is for our hourly non-exempt employees. That's the base rate we need to pay them. So with that, there's a few bullets here. Anytime there is a minimum wage increase, that also affects the salary for our non-exempt employees. So you can see that right there. And then there's a couple other smaller groups there. If you're using that inside sales exemption, they also have an hourly rate increase. And then the tool rate. Tool rate is more used like in construction type industries. That's if you're going to require employees to provide their own tools, they need to be paid twice the minimum wage. Okay, I do want to focus on that last indented bullet there. This is something the compensation folks would call compression. So you're not required to do anything, but with this increase to $16.50, then your other employees that are already at that rate or a little higher may have negative feelings. So if you're increasing people, let's say at $16 up to $16.50, then someone already at $16.50 then would be questioning, well, where's my increase? So you at the very least want to have a plan internally of how to address that. If you can increase those folks up somewhat, then that's an option, but at least have your talking points available because employees will come to HR or to managers with that. Okay, on this bullet, Sarah just wanted to touch one last thing on minimum wage is how we do have those industry specific and those local minimum wage rates still in place. So $16.50 is the base for California, but we know like fast food and other cities have a higher rate. Okay, thank you. So new posting requirements. This is, you can see our first bullet there is the first requirement was the commissioner was required to develop a model list of employee rights for this whistleblower law. So they did that, and look, that was done in time to include in our labor law posters. So if you're getting those posters from Cal Chamber, this is already included. When you get those next year, you'll see that in the top right, there is a large font for this section, larger than the rest of them. So that's already included there. We did include here a link to a one-pager with that notice. If for some reason you don't have the Cal Chamber posters, then you can at least have that as an option. Okay, jump to our next one, paid family leave. So you can recall this is something we have in California. There are some employers that have been requiring employees to use up to 2 weeks of their accrued vacation for that first part of the paid family leave. So this new law is saying that we can no longer do that. So with that, and as Nicole mentioned, just a great time of year to review your handbook, any separate leave policies. In addition, if you have any like template letters you use to employees. So you want to make sure you don't have this 2-week vacation piece in there, but also just a good time of year to review all of those. Okay, next, social compliance audits. This is a completely voluntary audit, but there are some companies that choose to do this. And the new rule is just saying, if you do the audit, then you need to post the findings publicly. So really this audit can be done often like a retail company, manufacturing, especially if they have global supply chains. You might see on some of these websites, they will proclaim that they have like humane practices and they're meeting all of these rules. That's because they've done an audit and they can say that, which is great. But now they're just saying, if you do that, then you need to go a step further and actually publicly post those findings. Okay, that's it for me. I will hand it back to Angela.
Thank you, Kristen. And I will dive into the Victims of Violence bill. And so currently, most of you are probably aware that there is a current law that allows for employees who are the victims of certain crimes leave and reasonable accommodation of safety issues. So now those protections are expanding in 3 key areas that I'm going to unpack. And the first one is the list of crimes that qualify as acts of violence has expanded. As you can see up on the slide, under the qualifying acts of violence, the domestic violence and sexual assault and stalking are still there. But what's been added as acts that involve a firearm or dangerous weapon are used or brandished are now included. So that's a little bit different. And you also must provide reasonable accommodation for victims of domestic violence, sexual assault, and stalking. And this applies to employers with 25 or more and you can't discriminate against them for being the victim of such crimes or whose immediate family member is deceased. And I'm going to move to the next slide. And so this new requirement also includes a posting notice, and the posting notice is going to be provided to employees upon hire. There is currently a posting notice that you provide to them upon hire. And you also would want to provide it when you become aware of someone who has a scenario of a violence situation or anything like that. But now you'll also see that this law is expanded, and it includes the definition of a family member to include that designated person. So it mirrors that CFRA definition of family. And the designated person, I've had some questions about if it has to be the same person as under CFRA, and I think that would be a little bit cleaner if it was the same person that they designated under that law as well. And so the list of things that would be considered protected under if it's the employee or the family member would be, and this is again, taking time off for a qualifying act of violence, would be taking time off work to assist a family member when obtaining relief, such as a temporary restraining order, to seek medical attention to recover from injuries. And they don't define recovery, so that could be broad. To seek services from domestic violence shelters, programs, or agencies, to seek psychological counseling or mental health services. And again, it doesn't specify that it needs to be a licensed provider, to participate in safety planning or prevent future acts of violence. So this, again, very broad. This could be staying home to help a family member install an alarm system in their home, to relocate or engage in the process of securing a new residence, enroll children in new daycare programs or schools, providing care to family members recovering from injuries, to seek civil or legal services in relation to the qualifying acts of violence, and also to prepare for or participate in any civil or criminal proceedings related to that act of violence. And when these things come up, employers, they can ask for documentation, and they can also ask for advance notice for the employee to be out whenever that's possible. And then you can also ask for after the fact documentation. And then I'm going to move to the next slide. And here, again, just touching on those expansions, the employer needs to provide a reasonable accommodation for an employee whose family member is the victim. And I want to note, this is the first time we see protections pop up for family members in that reasonable accommodation space. So when you're thinking about reasonable accommodation for either the employee or the employee who has a family member who's been impacted, this could include the implementation of a variety of different safety measures. It could be a transfer, a reassignment, changing their phone number, changing their schedule, permission to carry a phone at work, or installing locks, things like that. And just a reminder, for something to be considered unreasonable, it would need to be a fundamental disruption to those business operations, not just that one unit. There are some time limits that the employee can take, the employee is limited to take this time. And just focusing back on the slide, as you can see, if it's time off for the actual employee who has been a victim, they would have that full 12 weeks that would run concurrently with CFRA and FMLA. However, if the time that is requested is for the employee office, for the employee's family member who's been a victim, and the family member is not deceased, but they themselves were not a victim, and it was something really specific, like I need to help my family member relocate or enroll their child in a different school, Then, if it's for one of those very specific things, you can limit that time off to 5 days. Or if it's for one of the other reasons and it's, again, not for the employee direct, but the employee wants to take time off to help the family member, again, that they're not deceased and they were not the victim, then the total time can be limited to 10 days. I know that was kind of that's a lot there, but those are the specifications. And then lastly, there's another provision. This is a little bit separate of a law that also came into effect January 1st, is that employers are permitted to seek temporary restraining orders on behalf of employees if there has been a credible threat of violence. And that's meaning that there's a knowing and willful course of conduct directed at a specific person that either seriously alarms, annoys, or harasses the person that serves no legitimate purpose. The course of conduct is a pattern of acts over a period of time, even if it's a short time, that would evidence some kind of purpose, such as following or stalking. And the important thing here is that you need to be able to provide the ability for the employee not to be named, but you can still seek that temporary order to protect your other employees. Okay, and that wraps up this piece. And moving on to employment discrimination, and this is regarding driver licenses. And this is where it will be unlawful to include statements in job advertisements or similar tools where you might put postings about your employment opportunities that where you're advertising to applicants, that the applicants must have a driver's license unless both of these elements are true. One, you must reasonably expect that driving is a job function, and you believe that satisfying those transportation needs through the job function through some other way, like taking an Uber or walking, taking a bus, would not be comparable in either travel time or cost to the employer. And then also just a disclaimer, keep in mind that whenever you're posting your job ads, if you live or you do business somewhere in Los Angeles County or somewhere where a local ordinance might have extra restrictions, such as the fair chance ordinance for Los Angeles County, then there could be other considerations about what you want to be mindful of. And I'm moving to the next slide. And now we're just going to talk a little bit about Freelancer Worker Protection Act. And what I thought was interesting about SB 988 is that this makes a splash by introducing timely payment into the independent contractor world. So this applies to independent contractors who are hired to provide professional services of $250 or more. So this includes things like marketing, HR, travel agents, graphic designers, photographers, even your hairdresser, those types of things. And so if you have an independent contractor, it's stipulating that what needs to be in those contracts and how long you want to keep them. So the contract needs to be in writing and maintained for at least 4 years. And the elements that you're going to want to include in that contract are the basics, name and address of each person in the party, the itemized lists of deliverables and services that are going to be provided, what the value of those services are, and the rate of compensation for the services, and the date by which the services will be completed by the freelancer. And then moving on to the next slide. And then again, this is where that payment part comes in. The freelancer must be paid by the contract date, or if for some reason it wasn't specified, then it's going to be 30 days after the service is rendered. So it looks like you're going to want to get this right to avoid civil lawsuits. And let's take a look at some of the consequences of not providing a written contract when it's requested. You can see these are all the possible penalties for not doing that. So if a worker requested but was refused a written contract, the amount of compensation would be determined by the rate that the freelancer reasonably understood to apply to the work. So not by what the person hiring the person thinks is a fair rate, but what the freelancer decided. And the other piece would be that there's just automatically an additional $1,000 that could be applied. And if there was not a timely payment, the penalty could be twice the amount of unpaid compensation time at the time of the compensation was due. And there's also any other violations to this could be damages equal to either the value of the contract or the work that's been performed, whichever is greater, plus all of the attorney's fees and costs and any injunctive relief. And so this is something that if you do have independent contractors, if you haven't refreshed that, I would recommend probably reaching out to your labor law attorney to refresh those contracts. And with that, I am going to hand it off to Nicole to our next section.
Thank you so much, Angela and Kristen. That was great too. So this slide just summarizes some additional bills that were signed into law. Probably the top three are the most kind of critical. So the first one is that the Crown Act was amended slightly. The Crown Act is, if you recall, several years ago, brought into a FEHA protection protective category for certain hairstyles associated with race. And the language was hairstyles historically associated with race, such as locks, twists, and braids. This amendment was to eliminate that language of historically associated with. So you're going to want to go through when you're updating your handbook and just strike that language, those words from the long paragraph of protected categories under FEHA. But still keep in mind that hairstyles are protected. You can't have a certain maybe a dress code or something along those lines that prohibits certain kind of hairstyles that are historically associated with race. The second big change was amending FEHA to prohibit discrimination on the basis of a combination of two or more protected traits. This is called intersectionality. Again, you're going to want to go through and update your EEO policies, your anti-harassment policies, your anti-retaliation, discrimination policies, and add in a caveat that any of the protected categories already listed, there will not be any harassment or discrimination or retaliation based on that category or the combination of any of those categories. And this is very interesting because I had a case a couple of years ago where the woman was claiming that she was terminated not solely because she was a woman over 40 who had a child, but because she was the combination of that. She was a pregnant woman over 40, and that was the basis for her claim. At the time, we pushed back against that, but now it's clear that can be a standalone claim in and of itself with that intersectionality. So keep that in mind. The third main one is that Cal OSHA has been designated to propose a rule requiring first aid kits to include Narcan. When that's passed, I'm sure we'll be getting notices about updating our first aid kits and so forth. And then here are a couple other changes that are a little bit less kind of front burner, but still to keep on your radar in the new year. And then I always like to take a look at the vetoed or the stalled bills because they give us a little bit of a kind of crystal ball to what may be coming down the road. So if you don't mind going to the next slide, Sarah. The first one, thank goodness this did not pass, an increase in the statute of limitations for FEHA claims to 7 years. Can you imagine? A couple years ago, unfortunately, the statute of the time that an employee has to exhaust their administrative remedies, basically get that right to sue letter from the Civil Rights Department, expanded from 1 year to 3 years. We thought that was already too much because a lot happens in 3 years. One, people forget things, documents, kind of go to different locations. There was a proposal to increase the statute to 7 years. Thankfully, that did not pass. We're still dealing with the time frame that we have in front of us. Prohibition of using criminal history in making employment decisions. We already know that California and different localities like San Francisco and LA have very protective processes to go through with regard to considering criminal history, doing criminal background checks, and a process to go through if a criminal information is discovered as part of the background check. So you want to make sure you're still on top of that. And, red flags should go up whenever that happens, and you should be working with counsel on how to handle. But just kind of like that blanket prohibition is not currently in place. So that was vetoed or stalled. The right to disconnect bill, I couldn't imagine that this was going to be passed, at least today, but it would have granted employees the right to ignore work communication outside work hours, except in emergencies or for schedule changes. Do keep in mind, though, that if you are emailing or texting or contacting your non-exempt employees outside of work hours, that is paid time, and you want to make sure that that's captured and paid properly. So just a little takeaway there. And then on the next slide, there's been a lot of proposed bills regarding AI and use of AI in employment. Definitely keep that on your radar, and then a potential unemployment insurance tax increase as well. So we have a little bit of time to now delve into the cases. I picked a couple cases that I think are both relevant, but also provide opportunities for kind of reminders on the more important areas that we see come up when it comes to litigation and claims, and also advice and counsel. I do quite a bit of advice and counsel, so I'm talking to clients about day-to-day issues that come up, helping them navigate leaves of absence and reasonable accommodation and interactive process and pay issues, so there's a lot that we can take away and implement from these cases, and also just kind of reminders to keep in front of mind. The first case is Turrieta versus Lyft. And this goes to the PAGA point that I was talking about when we first started the presentation. So what we've seen lately is we've seen multiple PAGA claims filed one after the other, sometimes three, sometimes more. But, we'll have these kind of competing PAGA claims. So a different plaintiff, often the same or very similar claims, and different attorneys and different interests at play. And so we've been strategizing internally. We have a fantastic team of really like frontline PAGA and class attorneys. I do some of that work, but our team is really fantastic at really being strategic on how to handle this. In this case, one plaintiff reached a settlement in her PAGA claim, and the court scheduled the settlement approval hearing. The other two plaintiffs who had filed their own separate claims tried to intervene and object to the settlement and try to vacate that final judgment. The court rejected that attempt at intervention, and then the Court of Appeal affirmed that decision, essentially by saying that a plaintiff in one representative action does not have a right to intervene in a separate action or object or move to vacate that judgment. And the reason that the court said that was that PAGA actions, as I mentioned, they're disputes between the employer and the state, because the PAGA plaintiff steps into the shoes of the state and is essentially representing the state's interests, not an individual's interest, not the attorney's interests. And because of that, where the court finds that there has been a reasonable settlement of the claims, that is, that the state has resolved those claims, and those claims are kind of settled out in that prior one. So this is more of a kind of a legal case for us, but it's helpful when it comes to defending claims, particularly if there are more than one competing PAGA claim. The next case is Doe versus Second Street. In this case, you actually may have heard about changes with regard to compelling arbitration when it comes to claims involving sexual harassment and sexual assault. If you recall, the federal government actually enforced arbitration of harassment claims act was passed saying that you cannot, and this was kind of a post Me Too and past couple of years when there was really a lot of change with regard to sexual harassment, sexual assault, and those type of claims being heard. And what the bottom line here is that if an employee alleges any type of sexual harassment claim, even if there's an arbitration agreement in place, and I want to talk a little bit about the pros and cons of arbitration, all the claims have to stay in court. So, a lot of employers will have arbitration agreements. The pros and cons, can really be discussed at length, but in a nutshell, the significant pros are that you can try to break up a class action. So if you're a larger employer, you really want to think long and hard and probably go for having an arbitration agreement. You can't compel a PAGA claim to arbitration, but you can break up a class action. That's significant. Also, in arbitration, you're bringing the case to be decided by an arbitrator, oftentimes a retired judge, a very experienced employment attorney, rather than a jury. And the risk of a jury awarding very significant fees, penalty, damages, judgment, that's a real risk, depending especially on where your case is located. If you're in LA versus Santa Barbara, versus Oxnard, Ventura, all the different areas are going to have kind of a different jury pool, but the risk is much more significant in terms of a jury making a decision versus an arbitrator. Downside of arbitration is that in California, the employer has to pay the additional costs of arbitration, which can be very expensive. My colleague just told me that they got a bill from the arbitrator for $160,000. So you have to factor that in. You have to understand, if you have insurance, does your insurance cover those costs of arbitration? And really, what are the pros and cons, of enforcing an arbitration agreement? But know that if a claim is brought for sexual harassment or sexual assault, the whole case will stay in court rather than being able to compel that to arbitration. So that's the takeaway here. And if anybody has any questions about arbitration, I'm always happy to discuss that further. In terms of the Bailey versus San Francisco case, this is a case that has to do with a woman who worked in the San Francisco District Attorney's Office. She sued for race discrimination after one of her coworkers with whom she shared an office called her the N-word one time. The trial court granted and the Court of Appeal affirmed summary judgment for the employer because the standard that we look at in harassment claims is, was the conduct severe or pervasive? So, did this happen often? Was it pervasive? Or was it so egregious that just a one-time incident was significant enough to establish that harassment claim? The trial court and the Court of Appeal said that one-time incident was not sufficient, but the California Supreme Court disagreed and said that a jury could find that a single comment was sufficiently degrading and humiliating in the extreme. So the takeaway here is to make sure that your employees, and there's a training requirement, so once every 2 years for all employees, 1 hour for staff, 2 hours for management. Employees understand what is acceptable in the workplace, what is absolutely zero tolerance in the workplace, and make sure that that you're reminding employees about what the expectations are, the conduct, and so forth. Also, I just want to mention this before we go on. In terms of documentation, this is something I heard the other day that I think is kind of stuck with me. This was in a podcast about parenting, but the takeaway was, if you've heard the phrase, dance like nobody's watching, email like you're going to be subpoenaed. So anything that's put in writing, anything that's in a Slack message or a DM or an IM or anything like that, you want to be very careful about what you put in writing, because even those, jokes, I'm putting in quotes, or, not ill will comments can be interpreted differently. So speaking of DMs, in the next case, this employee was a staff psychologist at a federal correction complex in Lompoc. She discovered that a lieutenant with whom she worked had an online like Instagram page that contained sexist posts, anti-Semitic posts, racist posts, transphobic, some of which were directed at her. And 100 of the individual's coworkers happened to follow the page. She brought a claim for hostile work environment and harassment. And initially, the issue was that, this was not work related. This was outside the workplace, off work hours, which, we know that there's protection for lawful off duty conduct. But I have actually been navigating several issues over the past, I would say, 6 months, where an employee's off duty conduct has bled into the workplace, and employers have to decide what action is appropriate and what they can take. And it's a very gray area. But in this case, the Ninth Circuit concluded that off-site conduct, like this individual's Instagram page, can have the effect of altering the workplace in an objectively severe or pervasive manner. So employees should be aware that conduct off-site, off-work hours can impact the workplace, and employers have to be aware that certain steps might have to be taken if it comes up in the workplace. The next case I'll just briefly talk about, it had to do with an employee who was asking for time off to donate and freeze her eggs for potential future use. In this case, she brought a claim where her employer, she claimed, was not accommodating to her and ultimately terminated her for this request. The reason why I flagged this is because the law changed between when this case was filed and today. And so today there is protections under FEHA now for reproductive decision making. So at the time, the court denied her claims and said, you were not pregnant, did not have a medical condition, therefore you can't bring these claims. But if you brought these claims today, you would have a basis to move forward. So this again goes back to like how quickly employment laws change and how we really have to stay aware and on top of them, and make sure in your handbooks that you are including that language of reproductive decision making as protected category. And if you have employees asking for time off for those reasons, egg donation, surrogacy, egg retrieval, IVF, make sure that you are aware that it's a possible basis for accommodation and you have to go through that process. The next two cases are wage and hour cases. I think wage and hour is another topic we could spend a lot of time on. The first one is a case that had to do with boot up time for the computer, where the computers needed frequent restarting, and employees had to boot them up in order to log in, but also to do their job. They use the computers to make phone calls. In this case, there was an issue over whether that time was considered de minimis, and therefore not compensable. And the Ninth Circuit did hold that the de minimis doctrine is still valid under federal law, but that summary judgment was not appropriate at this stage because there needed to be a trial over whether or not the time really was so insignificant. What I want to point out for this audience is that in California, there is no de minimis standard. And a case came down out of Starbucks where the employees would clock out and then they would go outside and maybe they'd move the patio chairs to the side and they'd wait a couple minutes for their staff to be picked up. And the court found there's no de minimis in California. In this day and age, we are able to capture all time worked, and employers have to make sure that they're capturing that time, and we can't rely on that argument that it was too small to capture. That also goes to the responding to an email or a voicemail or a text message while a non-exempt employee is clocked out. So keep that in mind. The next case talks about it's wait time, where employees in this case had to wait in a long line at the security gate so they could be scanned in and their cars could be inspected. And then at lunch, and again, this is the construction industry, so, you know, could be a remote location, it could be a certain kind of work site situation, but the employee received an off-duty break but could not leave the premises. The court in this case said that the time that the employee was waiting for their car to be inspected and for their badges to be scanned had to be paid time. It was considered hours worked under wage order 16, and that meal breaks where employees are prohibited from leaving the premises are not proper meal breaks, are considered hours worked, and therefore compensable. And if you're not provided a proper meal break, there's a penalty, you know, very, very narrow exception for on-duty meal periods, which we can talk about separately. But make sure that you're not just paying for the time, you're providing a penalty if the employee can't leave the premises. Meal breaks and rest breaks are an area where we see a lot of claims and litigation. Make sure your policies are up to date and compliant, and that you're monitoring and making sure that you're reviewing your records to make sure that employees' breaks are timely, complete, and taken, and that they're clocking in and out for those breaks. We have employers who are not recording those meal breaks. You do have to do that unless you have a bell that rings and everybody breaks at the same time. If it's not the case, employees need to clock the start and end of their meal breaks every day and make sure that they're timely and complete. And on that note, with regard to wage and hour, keep in mind that really the driving force in a lot of these claims is the attorney's fees. In this Joe's Pizza case, the employee received only less than $8,000 after a jury trial. And initially, the trial court denied his claim for attorney's fees. But on appeal, the court held that no, under the labor code, an employee that prevails is entitled to their fees. And those fees in this case were close to $300,000 that were awarded to this individual. So, you know, this is just a reminder why it's so important to do those wage and hour audits, be as compliant as possible, and try to minimize those claims. And then the last two cases, and I'm so sorry that I'm having to rush through this, and hopefully we'll either have time to get to the questions, or if not, we'll absolutely follow up separately. But the last two cases have to do with reasonable accommodation. And reasonable accommodation, interactive process, those are areas that I've spent quite a bit of time on this year. I feel like the requests are getting more complicated. Employees are getting more kind of sophisticated in their understanding of what they can ask for, what the process needs to look like. But these are two cases where there were good results for the employer. The first one, the plaintiff was offered a leave of absence after being injured at work. She was deemed permanent in terms of her restrictions, and she asked for a medical retirement or a disability retirement. And her employer said, no, we can come up with some other job that you can do that you're qualified for. And then she went out on a mental health leave, and they continued to engage with her and provide whatever accommodations were available. And the court said that this employer had not failed to accommodate and had not failed to engage in the interactive process. So this is a good case to read in terms of the facts and the steps the employer took in terms of that interactive process. And then similarly, the next case from UC Berkeley, also the employer promptly engaged in a timely and thorough interactive process, evaluated all the possible accommodations available, had ongoing discussions with the employee, tried different things to see what would work and what wouldn't work. And so the court said, no, employer, you did what you had to do under the law. There was no failure to accommodate, there was no failure to engage, and ultimately there was no, discrimination or retaliation. So these are very complicated issues. Make sure that you're handling them very carefully and working with your trusted advisors on this. So with that, I'm so sorry that we filled the time, but Sarah, I'm turning it to you to see how you'd like to handle.
Yeah, we are right at time. We do have a handful of questions, and I think we kind of discussed if our panelists are able to stick around. We'll just answer these in the next 10 minutes or so, if you all are all right with that.
Absolutely.
All right. So to start off, we had some questions going back to the minimum wage increases. The first one, if you pay your hourly employees earned commission, does that factor into the $16.50 an hour?
I can start on that, and certainly Nicole, Angela, you can chime in, make sure I'm answering this correctly. Yes. So you have to pay them a minimum of $16.50. That can include commissions. You have to be careful, like if you're not paying commissions, maybe every payroll, maybe that's monthly, you still would have to then at least pay them that $16.50 with every payroll for all of those hours. Tips are not included, but commission, yes. Nicole, Angela, did I get that right?
Yeah, I'm happy to follow up on that. Yeah, we can definitely follow up. I think it's nuanced. It depends on the facts, but we can dig in later.
All right. Next question. Can an employer use an employee's vacation hours when they call out sick? This is when they have exhausted their sick leave hours.
Was that a required or allow?
Looks like allow.
Can they allow? I'll jump in on that. Certainly, you can allow employees to do that, to use their vacation if they've exhausted their sick.
Okay. By the way of the question, it sounds like it would be the employer choosing to use the vacation hours rather than the employee taking the action themselves.
Some policies they're drafted that any time off for any reason after you've exhausted your, any time off we're going to apply vacation. I tend to not want to kind of do that, even though employers can have a lot of control over a vacation policy. It's not required to provide paid vacation, so employers can have control over it. I think you just kind of want to think about the impact of that, the morale issue, and how that's going to come into play. There are other ways to have employees draw down their vacation bank, like scheduling vacation at certain times of the year. Maybe, if you're going to close between Christmas and New Year's, and having employees, giving them some notice that we're going to apply vacation during that time, that kind of thing.
Great, thank you. Okay, moving on to the Victims of Violence and AB 2499. Just some clarification, if we have less than 25 employees, are we exempt from the entire policy?
Yeah, the enhancements in that policy does apply to employers with 25 or more. I would just always be mindful when it comes to accommodations that you really want to examine that closely. But for the most part, the leave entitlements are applied to employers with 25 or more. But I'm always apprehensive when it comes to reasonable accommodation. Make sure you really understand the nature of the request before failing to, as Nicole just illustrated, engage in the interactive process and accommodation, because that could be less ADA as well as FEHA, and all those have smaller requirements.
And
but the action.
Yeah, that's a perfect point, Angela. And just to add on to that, employees can use their paid sick leave for those reasons too, and that applies to all employees, regardless of.
Yeah, and I saw that other question that came through on it about it's not paid leave, but if you combine your sick and your PTO, your vacation, then that entire bank becomes fair game if you combine the two. So,
yeah, good point.
Mm-hmm.
That kind of leads into this last question that came in. Is it ideal to have separate buckets for sick leave and PTO?
I love separating them because there are so many things that are tied to California paid sick leave that I don't like to have to get into the weeds when it comes to. I like to be as generous as possible with our vacation pay. And I've seen some policies where the employer will write explicitly, vacation must only be used for leisure and must be requested in advance. And, they really, really limit what that vacation can be used for by policy, which I don't know that really makes it very rewarding for the employee if you're limiting it to that extreme. And so just because there are so many legal things tied to that paid sick leave, I like to keep them separate. It just makes it a lot easier to manage. and makes your vacation time a little bit more flexible in terms of when you want to make changes to it, or if those things are pulled apart. But it is a business decision, and it's up to the employer, because thinking about vacation time, that's always an expense on your books.
Angela, I could not agree more. I think that's so well said. And the last thing is that employers don't have to pay out paid sick leave. So
That's
talking
right.
about expense, so if you have it separate, you only have to pay out the vacation bucket, not the sick bucket. And if you have it all together, you have to pay out the whole bucket.
Mhm.
Big consideration. My advice generally is to, if I can talk clients into having separate buckets, I will.
Very good point. Thank you for that clarification. Next question refers back to the freelance workers protection. How do I differentiate freelance worker for professional services versus services invoiced for reoccurring needs, such as office cleaning, window cleaning, maintenance?
I would say the short answer would be the ABC test, but I'm going to let Nicole elaborate to see if there's any other measurement that you would recommend, or if you want to elaborate on the ABC test.
I'm looking at the question, is it how do I differentiate freelance worker for professional service versus services invoiced for recurring needs?
Like an employee versus an independent contractor, or
There's under professional services, there's specific categories of workers. So we want to take a look at that list, see if these people fall under that list. If not, they could still be independent contractors. They might just fit into a different carve out on AB5 and AB 2257. So we can definitely take a look at that closer as well. I feel like so many of these questions are very nuanced. So employment law, never easy.
Yeah, and some of these we do have the person's requesting name, so we can follow up with those individually if need be. Okay, these last kind of few pretty much go into wage and hour, it feels like. So the first one, do we need to pay for after-hour phone calls if we provide their phone?
Yes. So if you're providing their phone, that's a potential reimbursement requirement. So you've met the Labor Code 2802, but you still have to pay them for their time. So if they're, responding to work calls, checking text messages, checking emails, that's work that they have to be compensated for. So kind of two separate ideas, but you want to make sure that you're meeting both.
Thank you. This next one, thoughts on if a person makes over 68,640 in a professional job, do we make them a salary for less risk with hour and meal and rest break rules?
I can start that. I know that was on the slide for minimum wage increase.
Mm-hmm.
So reminder, there's a lot more that goes into the requirement to become exempt than just that salary threshold. I see that you wrote professional job. We want to really make sure that they meet one of those actual exemptions. And I see it's saying for less risk with wage and hour. Some would argue that it could be more risky to classify somebody as exempt that really isn't. There's been a lot of large lawsuits about that, and employers have to go back and pay back overtime because somebody really wasn't classified correctly. So if they can meet one of those tests, then that is certainly an option. You wouldn't want to do it on just one person. It would be like all of the people in that role.
Yeah, this is a great time of year also to do an exempt, non-exempt audit and look at all of your people that you have as exempt, make sure that they meet both the salary and the duties requirement if they fall into that specific exemption, an area where we do see a lot of claims and potential exposure. So definitely work with your team on that.
Keeping with the wage and hour, can an employer require employees to remain on site during their 10-minute breaks?
Unfortunately, no. That used to be the case until a couple years ago. A case came down that clarified that even if employees, can try to make it to Starbucks and back within their 10 minutes, you still have to let them leave the premises. You cannot require employees to stay on the premises for rest breaks or for meal breaks. That's a potential, that is a non-compliant, and you do need to make sure you're addressing that properly. And take a look at your policies because a lot of older policies will have that language in there that employees can be required to stay on the premises. We need to make sure that's not in there any longer.
We did have a couple of questions that came with the registration that I just wanted to make sure we reference. This one's more broad sweeping, but they asked, how long do we need to keep paper documents if we have them stored on a computer? That's more of a general compliance issue, I imagine.
Yeah, I mean, I'll jump in. It depends on the type of document. I know that some OSHA related documents have longer timeframes, but for payroll and personnel, I would say a minimum of 4 years, because that's how long, most of those claims can go back. Angela and Kristen, I don't know if you have other thoughts on best practice or other recommendations.
I keep my paper files for a very, very long time, as long as I can, as long as I have the space for them, just because I never know when I might need them. I prefer not to purge personnel files if I don't have to, or unless the employee is requesting it. But if you have the space, I like to keep them if it's just a backup. If it's not something you have archived. But I think you were saying in duplication, the question was if you have the electronic file,
Oh, I'm sorry.
how long do you have to keep the paper? So if you have the electronic file, then I would say shred the paper.
Yeah, make sure it's. Mhm.
Yeah, but I have kept my hard copies that I don't have an electronic copy for up to a decade. And I don't know if that's the best practice, but we have the space. And so I have, because I want to be able to reference it if I need to.
Absolutely.
The last one that just popped in here, do employees who are in a lead role need to be classified as salary? What are the legal requirements for this, and how do they know how to classify hourly versus salary?
Nicole, do you want to jump on that one, Brad?
So again, does in a lead role need to be classified as salary? The answer is no. The legal requirements, so let's say we're talking about a manager, maybe they'd fall under the executive exemption where they're supervising 2 or more full-time employees. They have to meet both the salary requirement and then the duties, which is a specific analysis. Do they have to be salaried? No. If they are hourly, you're going to have all the requirements that you have for your other hourly employees. So tracking their time, paying them overtime, tracking their meal breaks, making sure they're taking their rest breaks. So, it's kind of, I don't know that it would be the best move, but you do want to just look at this very carefully to make sure that your employees are properly in the right category. And this is an area where, the duties part of it, that's a very fact-based analysis. The salary is the black and white side of it. So the salary threshold, if you don't meet it, you cannot be exempt. But there's really a lot of gray area on the duties. And, I've seen the labor commissioner interpret them one way, courts interpret them another way. And so definitely, an area to look at closer.
Is there any sort of guide for hourly versus salary analysis audit?
Yeah, there's actually the criteria. I mean, you can look them up on CalChamber. That information is free on CalChamber. You don't have to have a membership. And I like to, every single time an employee is promoted, even if it's an existing job, I like to sit down with the manager and do that exemption test no matter what, because a lot of times if an employee was recently promoted, they're still rooted in their old job and they might be doing those non-exempt duties more than 50% of the time. And I'll just say, hey, why don't we check in another 90 days and make sure that and see maybe they've been able to relinquish some of those non-exempt duties so that they're truly meeting that test. And so I do think it's important to go through, because the duties test is different for each type of exemption. And there's more than one type of exemption. So I do think it's important to look at that criteria specifically. And sometimes you have to run it through more than one criteria. We might run it through the managerial criteria or the administrative criteria to see which one fits best with the duties test. depending on the role, it might be a little bit ambiguous as to where it belongs. And those are posted on the Cal Chamber website. I think that's a good resource to use. We also we can share those with you, or your labor law attorney can share those criteria with you. But I do think it's important to evaluate it each and every time.
Yeah, that's a great point. And just to add on to that about reviewing and updating the job description to make sure that it aligns with the exemption. I even put in language in the job description, what are the essential job functions that are the exempt duties, and that the employee has to do those more than half the time. And if they find that they're not, they need to let their supervisor know. And that job description is going to be a critical document when you're doing that reasonable accommodation interactive process, protocol. And so there's so many reasons to have current and accurate job descriptions.
Can you get penalized if someone is classified incorrectly?
Yeah. So if somebody's classified incorrectly, they could have a claim for unpaid overtime, missed meal and rest breaks. And, you usually don't track time for exempt employees like you do for non-exempt employees. They could claim they were working, round the clock, and you really won't have the documentation to prove otherwise. And then what they're claiming is going to be presumed true until we can refute it by witness statements, emails, whatever it happens to be. So the potential exposure is high, especially for those making a good amount of money, because the overtime is going to be based on what they're paid. And so I had a situation where, the claim, it ended up being very expensive for a fairly high level individual who the labor commissioner just didn't agree was exempt.
We're sitting just over a quarter up past the hour, so I think we'll leave it there. I'll hand it over to you, Angela, to wrap us up and close us off.
Yeah, so thank you so much to Kristen and Nicole and Sarah and everyone who attended our webinar today. As a reminder, you're going to receive an email in the coming days with a recording, a copy of the slide deck, and our added FAQ resource. And if you have any additional questions, please feel free to reach out to either HR consulting team or Nicole if you are seeking legal assistance. And thank you so much.
Thank you.